Today, Connor and I are going to be talking about data, DSARs and disclosure. And the inspiration for this talk, hopefully, is somewhat self-explanatory, especially given the number of people who signed up, which is simply that DSARs have become part and parcel of employment litigation now. We're all used to seeing the results of a DSAR in an employment tribunal bundle. And really what we want to accomplish today is two things. One of which is to help you feel a bit more confident in dealing with DSARs as they affect litigation, and perhaps go into a little bit more detail on some of the problem areas that are not normally covered in the standard GDPR training that we've probably all done. And second, if you already are or are considering adding value to clients by advising on data protection issues, particularly as they arise in employment tribunal settings, we think that this is quite a good jumping off point, because when you look at DSARs in a bit more detail, you're also basically having a whistle-stop tour of the underlying mechanics of data protection legislation. So we want to cover kind of 6 broad topics today. We'll start with a very brief refresher. It's almost certain information you've covered before, but it is useful just to touch base and make sure that we all have in mind the underlying mechanics. We'll look specifically at DSARs and litigation, but particularly the case law around what impact that has on the validity of a DSAR if it is being used as pre-action disclosure. Once we've dealt with that, we'll look at, from the employer's perspective, the data controller's perspective, what do they need to be searching for? What is a reasonable search? And that is an area that causes people quite a lot of grief, particularly when it occurs in the setting of ongoing litigation. Once you've done that, once you've got your personal data as a result of the DSAR, what do you disclose and what don't you? We'll look at some exemptions, and we'll also consider not just what a data controller doesn't need to share, doesn't need to disclose, but what they really shouldn't, and the liability that they may expose themselves to by sharing something that they shouldn't. We'll look at what happens when you get it wrong. If you're a claimant, if you're for a claimant or a data subject, what recourse do you have if a DSAR is refused? And lastly, we want to very briefly just give you an update on some legislation which is pending in Parliament, because that's going to slightly change things and is probably a useful thing for employment practitioners just to have in mind. But before we get into the nitty-gritty, probably useful just to remind ourselves of why this matters and why we should care about any of this.
Absolutely right. We've set out on the slide there for claimants and respondents. Of course, we're looking at DSARs today for the purposes of employment tribunal litigation, and that's why we've set it out as we have. So starting off with the claimant side, those of us that might represent claimants or indeed respondents. So the claimant side, the answer I think is fairly obvious, and as we'll come on to, it's a really useful tool to try to get perhaps some early disclosure or third-party disclosure, especially by comparison to the rules for disclosure in the employment tribunal and by extension the civil courts. The use of DSARs can expose as well wider breaches, things that either amount to a claim that might be brought in the tribunal, perhaps discrimination that the claimant didn't see coming or something of that nature, or indeed breaches of the UK GDPR that weren't foreseen. And finally, to put pressure on respondents, generally those who represent respondents may well be aware of just the difficulty that DSARs can cause. For respondents, again, I think perhaps it's self-evident to a certain extent. DSARs can cause a lot of stress, especially where it's a small business, perhaps, and receiving the DSAR causes worry and concern, and indeed a loss of resources in trying to deal with it. The concern is, of course, not only that, but also the liability that comes with not complying properly with the subject access request, either regulatory action or indeed claims brought against the respondent as well. And indeed, as we'll see, it can affect tribunal litigation as well. Moving on then, just going to do a very brief refresher on what the UK GDPR is and does.
We'll just carry on while we try and solve some technical issues with the slides.
So the UK GDPR will be familiar to many, but again, just a quick refresher for those who may not have seen it in some time. This is the UK's rules about how personal data is collected, processed, stored and shared. It is retained EU law, the UK GDPR. It's complemented by the Data Protection Act 2018, which implements and modifies the EU regulation. Just as a small aside, we have to be mindful of CJ EU case law post January 2021. Of course, Brexit has affected things somewhat. It's persuasive, but not binding. In summary, the UK GDPR gives individuals, the data subjects, rights concerning their personal data, and it places on data controllers, in this case, the employer and data processors, duties to protect those rights. The one we're really concerned about today is the data subject's right of access to their personal data. We've set out on the slide there Article 15 UK GDPR, which is where the right is enshrined. The right of access essentially gives the data subject, the individual, likely the claimant in this case, the right to obtain from their employer as controller, first, confirmation of whether or not their personal data is being processed. The answer to that is almost certainly that it is. The right of access to their personal data, which is certainly the receiving a copy, which is certainly the bulk of the burden for respondents' employers, and indeed the right to receive certain supplementary information, how and why data is being processed in relation to that individual. The data subject access request is the form, if it can so be called, of the request for receiving those things. So what does that mean? Very briefly, personal data is information relating to an identified or identifiable data subject. Someone is identifiable if you can identify them. It perhaps goes without saying, but that can be direct or indirect, which means that it doesn't necessarily have to be a name of an individual. Perhaps redaction doesn't go as far as to cover an ID number, or it could be an age or their location. Anything especially in a data set, perhaps, that from which someone can be identified. The long and short of it is that if this is information about someone and you can work out who that person is, it is personal data. Processing is very broad indeed. If the employer has that data, more or less, they are probably processing it. What happens if an employer is processing that personal data? Well, the employer first has to have a lawful basis for doing so per Article 6.1 UK GDPR. As the data controller, that will almost certainly be the case, subject to some very minor caveats. the employer needs to be clear in advance which of the bases they rely on. So this is something to think about well in advance of having received the subject access request. Also worthy of note is the special category data, and we've set out Article 9.1 there on the slide. It can be about racial or ethnic origin, it can be medical data, philosophical beliefs, and so on, and that might well be something that an employer has about their employees. If an employer does have special category data, then they must meet one of the conditions in Article 9.2 as well as having a lawful basis. These are all things to think about in advance because they are things that have to be passed on as part of the subject access request response.
And it's worth saying, isn't it, also that I mean, one of the things that is probably quite likely to crop up, especially with smaller employers, is that if you're as an employment practitioner advising them, unfortunately, you might be having to have this discussion with them after the fact, trying to work out how far that policy did or didn't go, or what it's left out.
Exactly.
So it is useful, even though it should have been done beforehand. You know, 5 times out of 10, you're going to be having to give some advice on this anyway.
Exactly right. Just thinking about what a subject access request is and might look like, it can be really in any form that there is no prescribed form for how it is put together. It can be made at any time, including during litigation, and so that's something that Felix is going to talk to us about shortly. And indeed, it can be made either through the Information Commissioner's Office's website, orally or in writing. The Information Commissioner does discourage the use of oral subject access requests. But that doesn't mean that it can't be done, and indeed it can be made to anyone as well. So that can be employees of the company, any employee of the company, or indeed representatives as well. And so it's really important, we think, to just have one eye on how that might be handled and making sure that those most likely to receive a subject access request, especially if it might be in the course of litigation, are aware of how to spot one and what it might look like. Broadly, in terms of how to respond, the normal time limit is a month. Although the period can be extended to 3 months if necessary. Often that's because a subject access request is complex or the search needs to be extensive. So that is the response. But if an employer is unsure about whether or not it's a subject access request, it's well worthwhile going back to the data subject and clarifying within the month. Just a really practical point, which is, well, then how do we spot subject access requests? We put on the slide here, I think, a fairly comprehensive example of what a subject access request might look like. But the real takeaway is that it doesn't actually say that it's a subject access request, and it doesn't mention any of the legislation that it comes from. This is a request that is clearly with respect to discrimination and victimisation claims, and yet it can still be a subject access request, so it's relevant for both of those purposes.
Yeah, and I think the point is that you as an employment practitioner may be just having to disaggregate between quite a lot of different things that are happening in the same message, and this is something we'll talk about in a bit, but obviously there's stuff there in terms of requests for explanations of why a decision has been made. It's not really anything to do with the subject access request, but it's obviously relevant to the employment claim. And this DSAR contains a lot of examples of information that's being sought that might be covered by an exemption. So one message can contain a lot, and it's well worth taking a time when you first get that and disaggregating between what's relevant for an employment claim, what's relevant for in terms of data protection litigation liability, and then just keeping a note of the different types of information that are being requested and whether an exemption would apply. So, let's now imagine we've got this DSAR, we've given that example, and we'll be thinking about how we respond through the rest of this webinar. It's being used as a form of pre-action disclosure. It doesn't make any bones about that. That's what it's being used for. Does that impact what a data controller, in this case the employer, is entitled to do? And the answer is not really. The case on the slide is Dawson-Damer, and that is helpful because paragraph 112, Lord Justice Arden, speaks in terms of collateral purpose. So if the main purpose, or theoretically the main purpose, is getting access to your data per Article 15, if there's a collateral purpose of assisting in litigation, that does not make the subject access request invalid. And just a tiny point here. A lot of the cases we're going to be talking about are pre-2018, and are going to be referring to the Data Protection Act 1998. But those cases still apply. It's the same principles, and they've been applied fairly unproblematically in general. The other point to note is if you are going through case law, you will find that there are some cases, and Lees and Lloyds Bank is an example, where there's a discussion of the court's discretion when it's considering whether or not to enforce compliance with a data subject access request. And the court, in its discretion, sometimes does have reference to the fact that something is being used as a form of pre-action disclosure. But we need to differentiate between the court's discretion and what the duties of a data controller are. So the long and short of it, and the ICO have been really, really clear on this, particularly as regards employers. You've got to respond to the subject access request as though the litigation didn't exist. That said, just because something is being treated as a form of pre-action disclosure doesn't mean it is pre-action disclosure. That obviously, it sounds like a very obvious point and something that doesn't need stressing. But it is surprising how many times people go slightly beyond what they need to do, and sometimes massively to their detriment. We know from the civil procedure rules, which the tribunal will have reference to, that disclosure, standard disclosure, is about information, the documents that affect the case, either adversely your own case or somebody else's, or supporting another person's case. But what is relevant is how that document affects the case, and that isn't the same, is it, in terms of the scope of personal data when you're making a DSAR?
No, and well, that's the thing, isn't it? While there is a distinction between the two, so we have the civil procedure rules that, of course, the tribunal will have regard to on one hand, which are about the case. And then on the other hand, we have personal data, which is, of course, about the individual. It can be, it's not necessarily that one is wider than the other, but of course, they both have their own separate purposes. What we do highlight, though, or what is worth taking away, is that while they do have a different scope, there is potentially a significant amount of overlap between them, especially in an employment context. And it's something that certainly I advise my clients as claimants to do, because it's a cheap and easy way of potentially getting disclosure of documents at a very early stage where otherwise they wouldn't be able to get them through the tribunal or even the civil courts. And it's likely to be beneficial to claimants with very little detriment or risk to them. Just thinking about how things might differ, we've put on the slide there the case of Ashley and Revenue and Customs Commissioners, which is a very recent High Court case. In Ashley, the claimant essentially wanted to know about how his properties were valued. The question was whether the data was relating to him, the person. It was found that he was entitled to data that was concerning his properties, but he wasn't entitled to all the information generated in the investigation, nor HMRC's internal processes. And we've set out paragraph 161 of the judgment in part there on the slide. It's well worth having a look at that in terms of how all this applies. We can readily see the relevance in employment claims. So it might be that a respondent, for example, has a smoking gun. There's an email between managers, for example, discussing the economic health of the business, where redundancies are proposed, but that economic health suggests that, in fact, redundancies aren't needed. That might be information of great importance to the data subject, but it won't necessarily be information about them. And so respondents ought to be quite careful about what it is that they are disclosing, of course, comply with the data subject access request, but be careful about oversharing.
Yeah, there's no need for unilateral disarmament, essentially, at an early stage. And again, while it seems like quite an obvious case, it's surprising how many times you go through the response to a DSAR in a claim, the information that a claimant is seeking to rely on, and find stuff that didn't need to be shared, really didn't. So again, in the heat of the moment, it's easy to overshare, perhaps, to disclose things that need to be disclosed. And it's again another opportunity for employment practitioners, if they are called in early enough, to add quite a lot of value. So on the subject of keeping things separate, we've got one document in the example we've got, but it generates kind of two sets of liabilities. One is as data controller, and that's what we're going to be going into in a bit more detail later on. But at the same time, we shouldn't lose sight of its potential implications for that employment claim. And Connie, do you want to walk us through some of that?
Absolutely. So while the Employment Tribunal doesn't have jurisdiction to hear complaints about breaches of the UK GDPR generally, as Felix has said, it's really important not to lose sight of the implications for the underlying Employment Tribunal claim. A failure to respond may itself form the basis of a new complaint. As we've said, although the time of compliance, the subject matter will probably differ from disclosure obligations in the Employment Tribunal or civil courts. An employer who fails to respond, particularly to a data subject access request, perhaps on allegedly on the basis that an employee is bringing an Equality Act claim, then opens themselves up to a victimisation claim. Another member of Chambers appeared in the EAT on a relevant case, and that's the Chief Constable of Merseyside Police and Knox that we've set out there on the slide. In that case, it was a key feature of the case that a failure to comply with data subject access requests was a detriment that was capable of supporting a claim for victimisation. In the EAT, the decision in favour of the claimant was overturned on evidential grounds, but the underlying principle remains valid, but it may well amount to victimisation. As we've seen, a SAR may form only one part of a message asking for more information. It's worth bearing in mind that if an employer refuses to answer a question by an employee, regardless of whether it's accompanied by an SAR, it can also lead to negative inferences in discrimination claims that can be drawn against them by the tribunal. That, of course, is the now amended question and answer process following the statutory questionnaire procedure being repealed. And the subject access request, of course, might be both. So it can be relevant as evidence in the ET claim, as well as being a standalone claim of its own, perhaps in victimisation. Final key point to raise is that the subject access request might be very relevant for time limits. An employer's failure to respond to a subject access request can be responsible for depriving employees of key knowledge relevant to a claim, for example, for discrimination. And there was a Court of Appeal authority, HSBC Bank, and Chevalier Fortescue, which where it was essentially found that because the claimant was deprived of that information by failure to respond to the SAR, time limits ought to have been extended. It's also easy to imagine a situation where there's a course of conduct alleged by the claimant, and the failure to respond to the SAR, perhaps in being a victimisation claim, can then bring the remaining course of conduct in time. So really important to consider, although entirely separately from the tribunal litigation, it can have real knock-on effects. Just thinking about the exceptions that are included in Article 12, data controllers are entitled to refuse a subject access request where the request is manifestly unfounded or excessive. Really, we think that this probably isn't an easy escape to responding to the subject access request. There is no bright line here. Broadly, the SAR will be manifestly unfounded where the data subject is not actually interested in the information. They're openly seeking to cause disruption or targeting another employee. It could, for example, be that the data subject is sending a high volume of subject access requests without waiting for responses, therefore clearly uninterested in the outcome. The manifestly excessive point is that broadly it's unlikely to be a way out. It could be that, for example, an employee is asking for any and all data about them across their entire employment. Perhaps they've been employed for 10 years. It might be that that's regarded as manifestly excessive because it's a really significant period of time, which makes the response almost entirely impossible. By contrast, we invite claimants to make targeted requests for whatever it is they want. If it's in relation to the litigation, it could be that they're looking for a particular email that might have been sent between two dates, and they can say that as part of their subject access request to ensure that it does bite and that it's maximised chances of it being responded to. As we've said, in practice, in our experience, we found that respondents have a tendency, if anything, to play it safe and to over-disclose. But this probably isn't the way out of doing that. It's more likely that it's better to explore the limits of what a reasonable search would be, as opposed to alleging that it's manifestly excessive. Again, it's a very high threshold in order to satisfy that, and that might be where those attending today come in, where they can add value by advising on the true extent of what's needed in terms of response.
Yeah, I mean that's a good point. If we just kind of take a step back, we've had that example DSARs come in. We're looking at what to do. Is it manifestly excessive? It's a high bar, and it might be tempting for a data controller just to look at something and say, well, that's far too much. You mentioned, for example, emails across this enormous stretch of time, but that does not in itself make it manifestly excessive. And it may be that while part of the request is excessive, not all of it is. It's generally you've got to be pretty brave to make your stand on manifestly unfounded and manifestly excessive. Similarly, a question emerges to whether the data requested is in scope. We have assumed for the purposes of this webinar that the employer is unproblematically the data controller. That is normally the case. But a question emerges about the individual types of data that are being requested. And a data controller is going to want to think about, are they the data controller for that information? Most of the time, that's not really an issue because it'll be, records on company records. One of the things that causes a bit of difficulty is when you're talking about data that's being processed by employees. I mean, that's something we want to talk a bit more about in the next slide. But there's also, I think, a tendency for employers to assume that once employees are doing something, they are controllers or processors themselves, and that is not the case. Unless an employee is going outside of the scope of their duty as an employee, they're not a processor. They are part and parcel of the employer as data controller. It's something to be very clear about. And the case on the board is Morrison and supermarkets and various claimants, which is one of the big cases about vicarious liability and data protection legislation. The point there is simply that that's a case where a rogue employee is not acting in the scope of their duties, so they are not part of the data controller in terms of its primary liability as data controller. But if you're not at that level, you aren't a processor. You are simply part of the initial of the data controller. So it's tempting to make a stand on manifestly unfounded and excessive, and it's tempting perhaps to argue about whether something's in scope. But as Connor's pointed out, what probably will be more helpful to a respondent or a data controller is looking instead at what is reasonable for them to search for. There is no definition in the legislation about what the remit of a search is, or how far you need to go in terms of a search. But it's uncontroversial that, as part and parcel of the principle of proportionality as it applies throughout EU-derived law, that there is an obligation only to make a reasonable and proportionate search. What that is will depend on circumstances unique to each case, resources available to the data controller, how difficult the search is going to be, what you're going to have to get other people to do in order to get that information. But the point is that it's not a duty to leave every single stone unturned. And the last excerpt from Deere and University of Oxford, paragraph 103 up there on the board is useful. The mere fact that a further and more extensive search reveals further personal data doesn't mean that that first search was inadequate. It just has to be reasonable and proportionate. Putting that all together, a really good advice of these different concepts coming together is bring your own device policies. Very, very common that an employer will allow employees, or sometimes require employees as part of their duties, to use their own devices, potentially even their own mobile phones. And Connie, you were saying that when you were teaching, there wasn't a policy; it just everyone defaulted to using their own devices.
Well, there might have been. So I was a law tutor at Durham University, and it was common practice that everyone used their own devices. Naturally, it is very common in the academic world, as it is increasingly as people are working from home and the like. But I wasn't aware of the policy, and I think that just tells a cautionary tale, because no doubt I would have had personal data about my students through the course of their teaching, and had there been a subject access request, it would have made things all the more difficult to deal with, because I didn't know what the policy was as to how to deal with that. It was just kind of the normal part and parcel of doing the job. And as I say, I think that's a nice cautionary tale.
You as an employee, probably think about it too much, and I think people don't think about it too much, and then it becomes a problem once you've got the data subject access request. And if you come in early enough as a practitioner, you can really save people a lot of grief by getting them to have a policy and making sure that everybody's looked at it. And in fairness to Durham, maybe they did have a policy and you just didn't look at it. But, you know, if you can have a clear policy and point to it later on and say, look, if they are using their own devices, it's not on our watch, then that's going to help you out as the controller. But if you don't, although it's tempting to say, look, they're using their own devices, that's not on us, you can't possibly expect us to be the data controller. Actually, you might be. And so instead of heading things off by denying that you're the data controller, instead look at the ICO guides about reasonable searches. You're really not going to be expected to make people search their devices unless you've got good reason to believe they are holding relevant personal data. So again, useful to think in stages. Is it excessive or unfounded? Is it in scope? What is reasonable for you to search for? So we've done our reasonable search, and we've now got data which we need to disclose. And that's going to apply unless there's an exemption. And we're looking at Data Protection Act Schedule 2. Obviously, you're going to have exemptions for litigation privilege. We've put in some extra exemptions which we think are probably quite helpful for employers to have in mind.
Yes, as Felix has said, in the interest of time, we're not going to go through all of them. We've made a few choice examples, put a few choice examples on the slides, those that are particularly relevant to employment litigation. The first is management forecasts. So personal data, once you've done your reasonable search as a respondent, doesn't need to be disclosed in a response to a subject access request, where it is processed for the purposes of management forecasting or management planning in relation to a business or other activity. What's important to note is that the exemption only applies to the extent that sharing personal data would prejudice that. So disclosing the personal data would actually have to negatively impact upon the forecasting or planning. The ICO's lovely chosen example for these purposes is an employer considering reorganisation that might involve making employees redundant. If an employee made a subject access request before those plans were finalised and announced, the employer wouldn't have to disclose that information that perhaps that it was considering to make that employee redundant, because to do so would very likely prejudice the underlying planning process. The second of our choice examples is negotiations. Very similar process. So in addition to the exemptions for privilege, another exemption is personal data that consists of records of the intentions of the controller in relation to any negotiations with the data subject. Now, again, the exemption only applies insofar as the disclosure would negatively impact upon the negotiations. For example, a company might be in the process of negotiating with a prospective employee or a current employee about their remuneration package, or it might be negotiations with respect to an exit or something along those lines, and clearly disclosing that personal data about the management's view, for example, of the prospects of negotiations and the likely value and so on, would prejudice those negotiations, and so it wouldn't have to be shared. Finally, and no doubt companies' respondents will have a policy on this nonetheless, but confidential references, this is a fairly simple, unqualified exemption. There's no need to disclose personal data if it consists of a reference that was or will be given for the purposes of the data subject's employment or potential employment.
So that brings us on to the last exemption we want to talk about, which is one you're probably already aware of. It's one that is the most complicated and is the one that is a potential source of liability if you get it wrong. And that's what is commonly called mixed data. So we're looking at paragraph 16 of Schedule 2. If my personal data, for example, is also Connor's personal data, there's an email that's discussing us both. The data controller is not obliged to disclose it to me if I make a data subject access request, unless either Connor has consented, he says, yes, I don't mind you showing that personal data about me, or it's reasonable to disclose it without that consent. So paraphrased a bit on this slide, but the important point is that is a decision for the data controller to make, and there are mandatory points that you need to consider. And they aren't that surprising. What type of information is it? How private is it? And any duty of confidentiality. We want to leave some time for questions, so we're not going to go too much into the duty of confidence as a concept and a breach of confidence as an equitable doctrine. But a prime example of where a duty of confidence might arise would be something that happens in the course of a grievance procedure or an investigation. If Connor is given, evidence on the understanding it remains confidential, let's say it's never used in a disciplinary or grievance procedure, but that information remains on file somewhere. It was given in confidence. It's going to be unusual for that to be reasonable to disclose that to me. And obviously, you want to have a look at consent. If there wasn't consent, well, why was it? As Connor said very loudly and clearly, please don't share that. These are things you're going to have to think about. But when you use a data controller, or as you advising someone who's a data controller make that decision, you do have a bit of leeway. In case of DB and General Medical Council, and this wasn't actually a unanimous decision, but Lord Justice Ailes was with the majority, gave judgment for the majority. And paragraph 86, what he's doing here is he's discussing the scope that the data controller has. What is their discretion? And the point he's making is that it's a wide one. You've got to just look at the mandatory requirements, but it's up to you if you want to look at some additional factors, and it's up to you what weight to give them. So perhaps the lesson here is keep a record, or advise a data controller to keep a record, simply so that they can show how they've exercised that discretion and what they've looked at and what weight they've given to things. But there is a wide discretion here. Why is it important to get this right? Why have we stressed this? Well, the answer is pretty simple. If personal data of Connor's is shared with me, and it's something very private, or it has significant negative effects for him, that over-enthusiastic response to the subject access request has now become a source of liability. Connor has a cause of action. People will often talk about breach of confidence in these circumstances. It's pretty rare, actually, in terms of low-value data claims. It's much more likely going to be breach of the UK GDPR or misuse of private information, a relatively new tort, which is essentially a common law tort which protects claimants' Article 8 rights under the European Convention of Human Rights. And that is perhaps a subject for another day, but the point is that MPI claims and breach of the UK GDPR, those claims are very, very frequently brought together. So that's the liability that we're looking at. In terms of once we've done all of this, we've exercised our exemption, we've looked at what exemptions apply, we've disclosed that data. If I'm for the claimant or the data subject and I don't think it's a good enough response, what can I do about that?
Well, that's exactly the question, isn't it? And we've got three options, I suppose, on the slide there. The first is that as a claimant, you can complain to the ICO. The important thing to note in relation to that is that ICO fines are relatively rare. They're usually reserved for the most egregious cases, and indeed they're published as well. And so realistically, for the purposes of a single complaint in run-of-the-mill litigation, it's unlikely that a fine would be levied, but it's still worth bearing in mind. There is also, especially data is intentionally destroyed, the risk of criminal prosecution. Section 167, the application for a compliance order, seems on its face like it might be useful, but realistically, it's probably not going to be used during the course of litigation. There are, in our opinion and experience, better options for encouraging or enforcing disclosure obligations within that litigation, either by an application for specific disclosure or either third party or pre-action disclosure. There are limits to that. So I was involved in a case where disclosure was a significant issue, and we came up against that buttress that you can't have pre-action third-party litigation. So that's something that is worth bearing in mind. But realistically, by the time a compliance case comes to fruition, it's unlikely to be useful in the end.
Yeah, I mean, it's worth saying. I think that was a PI case.
It was, yeah.
So exactly. I mean, in the employment tribunal, by the time you get a compliance order, if you do get one, the time would have passed.
Exactly right. And the final option, again, is an Article 82 claim in the civil courts, often brought alongside claims for misuse of private information, but realistically not particularly of use in the underlying employment tribunal litigation.
No, I mean, so can you just make sure we have a look at the questions actually? So
yes,
of course. See if answer them if we can. So the point in Article 82 claim is that it's a separate. It entitles you to damages for material and non-material damage suffered as a result of the breach of the UK GDPR. Now, realistically, if the breach consists solely of a failure to respond adequately to a DSAR, it's going to be, I think, unlikely that you're going to bring a claim for that. Some people do. But this is perhaps a situation where it's more likely to be an additional factor in a case where, for example, there's already been a data breach, or you make that DSAR as a claim and you get a response back which shows that actually, your data is not being processed properly. People have been doing all sorts of things. In that situation, maybe people are going to be bringing claims. Briefly then, what is non-material damage? Non-material damage is distress, and in the vast majority of cases, this is what people are claiming for. Distress is not the same as injury to feelings. It is not that generous an award. There's back and forth about whether there's a minimum level of distress, and unfortunately that's a common feature of data protection law, is that there's lots of interesting questions, and the courts say, gosh, what an interesting question, and they never quite decide it. But historically, UK courts have been very down on low-value data protection claims. In Johnson and East, community homes, is suggesting that there needs to be above a minimum level of distress. EU case law to the effect that there can't be individual member state cannot set a minimum level of seriousness. Of course, that's non-binding. This is after the Withdrawal Act, but it remains unclear how UK courts are going to respond to that. They've had an opportunity in recent cases to discuss it, but they haven't come to a conclusion. The measure of distress. It is going to be calculated with reference to psychiatric injury in the Judicial College guidelines, and that might make you think you're going to get a lot of money for it. But obviously, it's going to be, you're not. The point is that they didn't want distress to exceed what you would get for actual psychiatric injury, and so what you tend to see is relatively modest awards in the low thousands. You are not necessarily going to get an enormous award, and it's important to understand from the beginning that this is not comparable at all with vento bans. TLT is a good case there because you're dealing with some breaches which are relatively serious in terms of people's personal data being put online. but still, most people weren't getting over, £3,000 mark. So something to think about early on if you're a claimant, and something to bear in mind if you're advising a respondent on their liability in the civil courts for data protection claims. So lastly, a bit of an update about what we can expect. Data controllers have not been shy about how much of a burden this is placed on them, and probably everybody on this call is aware of how much the GDPR, now the UK GDPR, gives people grief. For a while, there were discussions which finally bore fruit in the DPDI bill, Data Protection and Digital Information Bill, that was introduced under the Conservative government, and that was going to reduce that threshold in terms of refusing a request from manifestly unfounded or excessive down to vexatious or excessive. And that would have been quite a useful and important downgrade for data controllers. And it's something, if you've been paying attention a bit, you may have seen this being discussed. Because the DPDI bill failed when the Conservatives lost the general election, that's gone, that's off the table. It's been partially resurrected as the Data Use and Access Bill, but that reduction in terms of the threshold is gone. So for data controllers, unfortunately, fortunately, if you're for a data subject or for a claimant, the test remains the same. And as we said, it's a high threshold. The reasonable and proportionate search is going to put on a statutory basis, so that will be spelled out. That doesn't really change anything as far as we're concerned, because that's already very clear in the case law. Something that we do think is worth pointing out, and may well affect employment practitioners, is that partly because of the sheer volume of ICO complaints to the ICO, the bill is going to require data controllers, in this case the employer, to have their own process for dealing with a complaint about how a subject access request was dealt with before it gets escalated to the ICO. And the relevance there is that you're going to have prolonged contact discussing data protection legislation with the employer alongside discussions about the employment litigation. So something worth bearing in mind, and perhaps another reason just to keep abreast of the latest updates in data protection law. That's everything we wanted to discuss today. I'm going to very briefly have a look at some questions that we've got through and see how many of these we can get through.
I've been having a look through these, bearing in mind the time. Harvinder, thank you for your question with respect to the time limits case that I cited. That's HSBC Bank and Chevalier for Rescue. I'll give you the neutral citation, which is 2024 England Wales Court of Appeals Civil Division 1550. That's failure to respond to a data subject access request, with being at least in part responsible for depriving an employer of key knowledge, and the extension of time was according.
Yeah, and we'll be sending out some materials used in this webinar later, and if we keep a note of any questions that have raised and anything useful that we can say. So let's just have a scenario where the organisation wants to delete after 3 months, which I think is too soon, especially if this is required as part of an investigation. So it's that's what you're saying. Oh, we've got quite a lot of questions here. Well, we'll get through some of them, and what we'll do is we'll keep a record of who asked what, and we'll come back to you an email if we can. I'm sure we'll be able to answer these, but I don't think we're going to get through them in the time. How long should information be recorded? It's up to you to have a policy, but you should just have a clear policy and stick with it. I mean, we as barristers, certainly going to record things for more than 3 months. We've got ethical duties which require us to have personal data for a certain amount of time. So I think the issue is not about a set number of months. It's about having a clear policy that you justify. It's going to be X amount of time. It's X amount of time because and you put that in your privacy notice, so that at the time that people are providing that personal information, that personal data, they are aware of it.
Yeah, Sard, it does sound as if in relation to investigations, what you're really asking there is a very practical question, and that's a decision to be made in the particular circumstances. But it certainly sounds like you're asking some interesting questions of that policy.
Hilary asked a very good question. Hilary says some employers delete chats, messages, emails, etc. to try to avoid disclosure. Is it possible to obtain a description of deleted messages via a DSAR? Two things. One, I touched on this very briefly. We didn't want to harp on about it because, I mean, hopefully most clients aren't doing this. It is a criminal offence to purposefully get rid of, delete information, data that someone has a right to access. But what that means is once that details come in, if you start deleting stuff, that's a criminal offence. Now I know that's not what you're asking about, but I think it's something that's worth stressing. Now you say that, what happens if you delete it, presumably ahead of time. Deletion, and again, we're happy to send you an email about this, but the ICO guidance talks about deleted messages. Just because something's deleted doesn't mean it's out of scope. Mm-hmm. Bear in mind that a lot of deleted items remain accessible in some format. So, for example, if I don't know, my deleted was the last time I looked through it, but there's all sorts there. You can't just say that's deleted, therefore I no longer have control over it. In terms of a description, I think that's your best bet actually. When you say is it deleted, is be specific in your request. That things may have been deleted, but to the extent that they're still accessible, you want information about them.
Yes, it's important to note that it doesn't necessarily mean just because it's deleted that it can't be recovered by someone with the appropriate expertise. There might be an archive of it somewhere. And again, in relation to that, all the guidance and the rules that we've set out throughout this presentation still apply.
Really good question here from Nehar. What happens? You've got a claim. You think of a potential claim. You're about to lose access to your company email or something, and you want to keep hold of information, and you don't want to not have it. What if you can you forward it to your own email? And the answer is no. Don't do it. And it's an unfortunate answer because it's obvious that one would have a great deal of sympathy with that claimant, but that is very likely to be a breach of the GDPR if you're just taking information that's been processed in one way and then taking that. Now, it depends on the nature of that information, whether it's personal data. But in any event, you shouldn't be taking company information and taking it for yourself. I mean, one thing you can do in that situation is make a careful record of what it is, and from the beginning say that I know this exists and I will seek a specific disclosure of it. And the same thing happens when in a professional context, when you're acting as a barrister or as a solicitor, you might come across confidential information that you're not allowed to have. You have to return it to the other side. But you can say, listen, I know this exists and I will seek disclosure of it. And of course, I will invite the tribunal to make the obvious necessary negative inference if, being on notice of this, you then don't produce it because you deleted it.
Exactly. Nehar, in terms of what advice I would give, I think the point is the one that was touched on by Felix. In the course of litigation, actually, it's probably way easier to seek specific disclosure to make an application to that effect, and then you can go to the tribunal and get an order for it in the tribunal, which of course will bite, assuming that claimant is successful. So that's probably the best way, in my opinion, of going about it.
Yeah, I've noticed we're coming to the end of the hour, and I think what we'll do is this. Just say briefly for those of you who have to go, we appreciate that this is quite often a situation where you don't know if you've got a real problem, where you need to instruct counsel to advise, or whether it's a 5-minute conversation. We could just say, look at Schedule 2, Paragraph 5. That's your answer. And if you are in that situation, please do reach out. In the information we're going to provide, you'll have our email addresses or go through the clerks. Sometimes it's just that matter of like a 5-minute conversation. So if you do have to go, we'll be in touch in due course with some materials. What I think we might just do, for those of you who've asked a question, I'm trying to try and work through what we've got left. Victoria, you asked, what about a situation where you've redacted the personal data or the name of somebody in your response, and they then come back and say, oh, well, we want that because it's relevant to my claim. Doesn't matter. It's not disclosure. You make your decision based on data protection law, and if the tribunal later says that you do need to disclose that, or that you do need to disclose it, that fairly obviously on the disclosure order, it's obvious that would apply to that. That's separate. But as regards a DSAR, you've made your decision about whether or not it's appropriate to share, and if they come back and say, I really want that because it's going to help me bring a claim against you, that's not really the test. We've given that case on time limits. Someone responded to Nehar's. So forward on redacted copies, keep a record of emails that exist. I think that's probably, in terms of data protection, I think is probably the right answer. And it's talking about other things to consider beyond that. If a company is part of a group that is outside the UK, does the DSAR cover correspondence to and from the foreign entities? If personal data is going outside of the UK, yes, you're still going to be. There are duties imposed as part of the UK GDPR about ensuring adequate protection if it's going outside of the UK. Good morning. How can I access the notes? We'll be in touch. We'll send you material shortly. Okay. Eda Haynes asked a really good question, which I thought might come up, which is the right to be forgotten in the context of SARs, or in particular with legacy bankrupts or material that have to be kept, such as accident records. So I'm assuming, Ed, that you're talking about a case where you want that information because it might be relevant to you later on, and someone has said, actually, can I get rid of that? Well, it's a similar situation, if you're in a data, if someone's made a DSAR and is then saying, can I get rid of that? Can I get rid of that personal data? I don't want you to refer to that. There are exemptions that apply, and one of them is scheduled to paragraph 5, that would be about prospective legal claims. So if something is being kept by you in regard to potential legal claim, I'm not quite sure of the context, but that is likely to apply there. So the ICO guidance on this, actually, sometimes the ICO website is not particularly helpful, but I think that is pretty clear. You've got in mind legal proceedings or the need to establish or defend a legal right. You use that exemption. So have a look at Schedule 2, paragraph 5. I think how the DUA bill impact legal privilege? It won't. Legal privileges. There are exemptions in the Data Protection Act, really to make sure that legal protection, litigation privilege is appropriately referred to. Yes. But the Data Protection Act can't and doesn't disapply the principle of litigation privilege. Right. Well, I think that's everything from us then. We'll be in touch in due course and send you some materials. And if you have asked any questions there, we'll see if we can add in some extra details in case there's anything that would be helpful. Thanks very much. And that's goodbye from us.
Thank you very much.